So are you okay with?
As long as like a reasonable effort has been made to do the investigation.
Right.
Somebody shouldn't be questioning that.
Mhm.
I just don't like it.
So do we want to combine them, or do we want to keep them separate? What do you guys?
I think I'm comfortable either way, so I think it's
Yeah,
really, I mean,
I'm comfortable either way.
okay.
It's just voicing the opinion there.
Yep, no, and that's
That's
why
a
you're
good
here,
opinion.
right?
That's why
I'm
we're here,
thinking about
absolutely.
past cases. We did, we've had some situations where students have left
Mhm.
just to get out of Dodge. And
Yeah.
there was really no way to go, and everyone was comfortable.
Yeah, I don't think I had anything
Anything
else. Nope.
Page 19.
I didn't have anything.
No, I did not either.
Page 20.
I didn't have anything.
Nope. So it's just a continuation.
Just, really the last part of the
Yep.
formal resolution.
Yeah. All right.
The only other comment that I had was regarding availability for the students. Like, because we live in the world that we live in right now with remote learning, is that on the table for a student for remote learning as a way of accommodating?
Yeah,
you know the question's gonna come up.
the only thing I would add to that is I would leave I'm gonna put a little broad statement that the district will look at option,
Right.
because I think we have remote learning now, but who knows what's gonna happen down the road, and this hopefully can go at least a few years.
Right, I can just see a parent coming forward and saying, you're doing remote learning now, why can't that be an option for my child?
And I think we would look at that option. We have looked at options in the past for kids who've gone to other districts,
Yep.
that kind of thing. So I guess if anything, I would maybe make a broad statement that we will work with the respondent as much as possible. If we wanted to add, because it does say you can add what you want
Right.
in that section. But, I mean, I guess I would leave it a little broader than remote learning, because remote learning could be an option. We have used VLAX for students that were uncomfortable.
Yeah. I just want to make sure that we're prepared for that conversation. should it
Yeah, we
arise
do have that
when we don't
conversation.
offer remote learning anymore like we are right now.
That's a great point, because the State Board of Education is actually
Oh, yeah.
looking at a rule to put in place that
Yeah.
they have to offer remote
Which-
learning.
Uh,
It's insane.
It
It's
is.
like another school that we have
It's
to
a
operate.
total, and again, if you can't even offer all the same classes, I
Can't do
mean,
it right now.
I mean, and I guess it- and I'm just thinking, it's an option, so it's parent, right? It's not like you wouldn't have those opportunities, but again, now we have to have literally another school.
Another set of schools.
I think that's, I mean, unless they're gonna start sending more funding our way,
That's
right? I mean.
what I said, I'm not even gonna say it. It's not gonna happen.
But to make that available, we should think about how do we make that available, I guess, for remote learners or,
Well, I guess what I'm saying, I wouldn't write that in there.
okay.
What I would write in there is maybe that we would look at other options that, if you want to add, because there's a place in here that says you can add something if you want to that list of what you would do for students, and maybe we can think of it as something a little bit more broader, saying that we would look at all options possible, make sure the child has an education or something like that.
Yeah.
Because in the past, we have offered VLAX, we've used Play-Doh for kids that were uncomfortable. And they might not even had an issue, they just got comfortable. That's why we have a Meadows program,
Mhm.
Right.
All right.
So then the next part of the packet is just the first,
One.
oh, yeah, go ahead, sorry.
Are we putting these GBAA-R and JBAA-R, are those going into this policy?
So that was one of the questions that I had. So first, the GBAA, they're saying withdraw that, and that's their recommendation. So GBAA was employees, staff to staff sexual harassment, and so they're saying withdraw that. But then, like you just pointed out, then we have GBAA-R. Should we can rename that, and we can rename it as AC-R, and that's really just kind of a reporting form,
Right.
which kind of helps organize, and I don't know, Esther, you can probably speak to that better.
It's nice to have it.
Is that helpful to have?
We have had over the years, people, because we had a reporting form, obviously, for a while now, and they have gone to what I handed out and filled it out and said, I have a concern.
Yeah.
So they have it in their hand and they knew exactly what to say. So I have to say, it has helped. It's a tool that
Yep.
people that are uncomfortable
Yep.
or having a hard time can use.
Yeah, the only comment that I have is GBAA versus JBAA, there's a blatant signature, like, make sure, I think we can
Kind
probably
of
get away
yield
with
both
one
of them. I
form
think so too.
to do.
From the School Boards Association, and gives us a little bit of direction, and then also talks about things that we should have put or should put in place prior to August 14th. And then the policy starts on page 2.
Okay. Page 2, section A, those first two paragraphs, is it just me or are they repetitive? There's a line in there, and it says, it starts in the first line, the purpose of this policy is, and then the very second paragraph, the purpose of this policy is. It's the same exact thing. Why do we have to say it twice?
So that was an A? I didn't even,
It's a very-
Section
yeah,
2A,
so
right? The second part of the first
Oh.
sentence there.
I underlined it.
right there and there.
Yeah, it's the same exact thing, and I was slightly confused as we had to, why the association had to say that same sentence twice. So maybe it was just me not reading it properly? Because then it goes into just regular harassing that doesn't meet the definition.
So there's definitely parts of, in the first paragraph that are not in the second paragraph, I feel like. And I mean, I guess we can work to meld those together.
Yeah, it was only that specific sentence that I had
Right.
underlined.
So the purpose of the policy is to address and only address sexual harassment as defined in Title IX. The same, right, same thing is really said in those first,
I think what they were trying to do is talk about the fact that regular harassment does not meet the definition.
right, which is in the second sentence of the second paragraph.
Right.
Yep,
And that those are governed by a specific board
another policy, right.
which I was fine with that piece. I just didn't feel that it needed to have that sentence
second sen-
again,
that
that very
sentence.
first one again.
Yeah,
Because I think for the average consumer, that, okay, so you've already told me the purpose, and you're gonna tell me the purpose again?
right.
Yeah, and I think too, anytime we can kind of condense this is gonna be good. You know, the 21 pages of a lot, although I think a lot of it's just, you know, provisional as far as, okay, we have to have this and we have to have that, but I do agree if we can meld things together, that'll just make it flow a little better. So, yeah, so I get take out the, well, what do we even take out here?
Would you take out the first sentence
first
of the
sentence.
second paragraph?
Yeah.
there?
Yeah.
Yeah.
Any thoughts on that, Esther?
I'm trying to figure out, there are two different things, that's the problem. One is talking about section 2B and section 3, and the other is really referring to policy AC.
Right.
So I guess I'm trying to figure out, is there a way to put that together, or is there a reason why it's two separate things? Because you're really dealing with two things. They're quite different. So I guess
Yeah, and that's what I couldn't
that's
figure
what
out.
I'm kind of having a perplexity here. I guess I'm really cautious about this policy and trying to go against our attorneys in this policy. And the reason being is this is federal, and so a lot of this came out of the federal language. And granted, now that's always not the most clear language in the world. I'll give you that. So I guess my concern is for us to change too much of it. But I see what you're saying, on that. But I guess my question is it two different things?
Right, and that's what I couldn't figure out.
Yeah,
which
you're
is why I
right.
had
You're
them
absolutely
underlined.
right. You're absolutely
I
right.
don't know if maybe we just need to change it to not say it's a purpose again.
Mm-hmm.
Yeah, it looks like it's just trying to re-emphasize the fact that it only is to address sexual harassment as defined in Title IX. And then it does, like you're saying, it drops that policy AC in as where you could find where else
Right, and that's not in the
harassing
top part. And
would be
that's,
governed, right?
yeah, and I guess that's,
Which I'm fine if that's a separate paragraph altogether,
right.
so that way it's clear.
I mean, you could almost start, if you got rid of the first sentence, you could almost start for harassing conduct, which does not meet the definition of sexual harassment under Title IX in this policy district. So you could almost add that and just take what you're suggesting.
Right.
And you
Take
still-
that
you-
first sentence out.
Yeah, and you still have the same,
I think you have the same
yeah,
purpose.
yeah.
And then the last paragraph, it talks about volunteers and visitors who engage in sexual harassment. It just says that they'll be reported, they'll be directed to leave the school, but nowhere else in this policy does it say, well, will they ever be allowed to enter the school again? If we can put something that says that they're not allowed on school grounds, and anything like that.
Similar to what it says about the third party
Right.
being restricted
Right, and we put it on there for third parties, but not for visitors or
or volunteers.
volunteers. So, okay, so somebody does sexual harassment that's a visitor or a volunteer and it's found, there's nothing in this policy that says that they're no longer allowed in our school, like it does for the third party.
Right. So
And I'm wondering if that's because
They're-
the federal guidelines is only pertaining to students, applicants, or employees, not visitors or general public, and that's why it does say it'll be reported to law enforcement. So I don't know if this statute, if Title IX covers that, and
It
that's
does
that
not.
footnote on the bottom,
Yeah.
is actually specifically saying the status of the respondents who are not students, applicants, or employees. It is not clear under the regulations. So I don't know if we even have that authority given to us to be able, so that's why, I think that's why it's saying it that way, because we don't have control over those volunteers and visitors.
I guess it's a question for legal counsel. If
Yeah.
we have the authority to ask them to leave the school or the property, and of course, we're going to report them to law enforcement, and they're going to handle the case. What is our jurisdiction as far as not
Right.
allowing them back in the school if it's found that it is a viable case?
Well, I think that's the key though, because is it just hearsay, is it just or because we're not gonna go through the process of the whole grievance process and getting a formal complaint and a formal answer. So if we don't have the authority to do that, then I guess it's really kind of a case-by-case basis. Again, do we find out after that it was completely fabricated, or do we,
But if it's a student, and they can make a formal complaint.
if it's a student, yes.
Against a volunteer or a visitor.
Oh, absolutely, yeah.
So then there would be a formal complaint there.
But we wouldn't necessarily investigate that formal complaint. I think that's what.
Right.
Yeah, we would turn that, I think that's how I'm reading it.
That's how you're reading it, and that's one of the things that came out of this, is that we've had this kind of issue before. And so we wouldn't necessarily, where they're not receiving funds from us, or they're not receiving education from us, or they don't work for us, we wouldn't necessarily investigate that. We would immediately turn it over to the police. And then the outcome of that investigation would make the decision of how you proceed. I mean, because it could be a parent that has children in school.
Right.
And then outcome of that would be how you proceed, and I think it would be a superintendent decision. So this gives you the flexibility to that. But I have no problem asking council either, but I think that that's what they're trying to achieve.
Do we have another policy or other provisions that allow us to ban somebody from school for, other reasons?
We certainly have, we have a policy about volunteers, and I think it is up to the discretion of the superintendent, if I remember correctly, to say, based on your background, because we do a background check on people, that you wouldn't be allowed to volunteer in our schools.
Okay. So do you feel if a situation arose where we had, a visitor, a volunteer engage in what we deem sexual harassment, we turn it over, goes through the process, we find out the person's guilty, we would still have the ability to ban that person from school?
Our school, I think so. I guess I'd want to check into that a little further.
Under the volunteer policy,
but
it's very clear.
And that's what I'm wondering, if that's why it's separate from this, because this, again, they're very specific in what they're
Well,
saying.
we can
This
look
isn't
into
applying.
it too.
Yeah.
It sounds like a good question, we should look into it.
And then the only other question they had for the first page is that it talks about educational programs and activities for the district. Where does school bus fall under this?
Well, the school bus is always an interesting thing,
I know.
because it's from the stop, when we pick the child up at the stop,
Yep.
where he's part of the school policy, so.
Yeah, no, I'm thinking specifically the school bus, because if I'm reading this, it's not an activity and it's not a school educational program to me.
The school bus would be considered under this policy once we pick the child up from the stop, because that's considered educational programming.
So they are ours once we pick them up at the bus stop, and then they're ours until we drop them off.
They fall under all our policies.
Right, I get that. I'm just looking at where that's an actual educational program. Just for definition purposes.
Yeah, well, it is considered an educational program, but,
I know I read something somewhere, it must have been one of the policies that we currently have that talked about the school buses as being school property or activities or
Part of the school.
Okay.
It was mentioned somewhere, I don't have it
once we pick them
noted,
up.
but, yeah.
I just wasn't sure if we had to list that.
I wouldn't think so,
Separately.
because on everything, it's considered once we pick them up.
Are folks open to comments from Peanut Gallery from time to time?
I'm okay,
Yeah.
it's a public meeting.
Yep.
Okay. I went through the first 10 pages and finally had to stop because there were too many cross-references between Title IX, this policy, the discrimination and the harassment. And as I read through this, and I did spend a few hours going through it, and I only got halfway through, and the question is, if this policy is put into place, is there really anybody who's going to know all of the ins and outs of this right off the bat? So the thought that hit me is that there's several different things at the 50,000 foot level you may want to consider. In that Title IX, this part of it was changed by the Obama administration, changed again by the Trump administration. It may get changed again with the next administration, or not. You never know, but you need to plan for that. This is trying to meld the Title IX process, or the strictures from the Department of Education, with the current harassment and discrimination. I would say, as an engineer, to keep those three things separate. It's one thing to follow the federal regulations, and another thing to have your own policies on harassment and discrimination. I would suggest that you keep all three separate and reference them only when necessary, because most of this that I read is more procedural. How do you deal with this rather than policy? So I would suggest that you look at it from that standpoint. Now I'll say something that may surprise you a bit, given my vehemence on Section C, Policy JBAB. This is going to run into, you're going to run into another problem because the Title IX has been rewritten so that sex is binary. That runs afoul of SB 263, gender identity here in New Hampshire. You may be at risk for losing federal funds in some absurd way. We all know how things happen within government, that you may again wish to keep things separate because of that. Whose law is going to be applied when? New Hampshire law or the federal regulations that are backed up by federal law?
Well,
Because that could be
Federal law
losing-
always trumps the state law.
Yeah, federal law will supersede. The reason they're doing this policy is because the federal law changed, as you were really clear about. And so the School Boards Association, like every school board association along the United States, has taken that law and has now created what they have recommended for us based on the federal law. So the federal always trumps state. So these changes are based on the federal. And part of it is, you're right, procedure, because that's some of the biggest changes is in the procedures. So, and in the recommendations, you put these procedures because they're so significant in our policy. So you're absolutely right, Skip, but it's federal. And this is really, basically, these changes and this information has come out of the federal. And as far as your first question, I've already been to a 3-day conference via Zoom on this, and we will continue to have to. I can tell you it has become much more of my job to understand this because it's become so much more significant, especially with the new federal changes and the continuous federal changes of every administration. And I agree with you, I think it's going to change again, so we'll have to be here again. But as far as Title IX, the one thing about the Title IX is that it really is a federal umbrella that they can put these things under.
Oh, that I understand.
Okay,
I'm
so-
just saying, you may look at this, instead of having 21 pages that incorporates all 3 things, that you keep it more modular because you would be in control of the harassment and discrimination, and then have this separated out by the Title IX procedures rather than policy. That way, if it changes, you can just swap whatever comes along instead of trying to make a whole hash. I never like omnibus type procedures because there's too many dark holes and too many dark corners that nobody really understands. And I'm just looking out and saying, no, keep it simple, stupid.
And I would agree with you in some respect to that. However, the dilemma I have with it is this policy, if I don't follow the procedures, is someone could lose their job.
Right.
This is significant, so this isn't something I would want just to swap out
Right.
as things change, because I think it's important for the school board, because eventually, if someone doesn't agree with my findings, which I've been very fortunate, I've gotten it in 22 years, I have, so, but if someone doesn't agree with my findings, then it goes to the school board. So I think this, I would totally agree with you on something else, and we do have procedures, but this is so significant because it is life-changing.
And we would never swap something out, we would always go through this process.
Right.
Well, swapping out, I use that just as a general term
Yeah.
rather than, take in, take out, whatever. I'm just looking at this going,
But if there were changes to this 21 pages, if we go through and approve it, which we haven't done that yet, we're still in that fact-finding process,
right.
we would read all 21 pages again.
And then you gotta go off, where I kind of stopped was because it's referencing other outside stuff, as, Esther probably well knows. Title IX is not a small amount of
No.
pages to read.
It's 2033.
And
Yeah.
I've read most of them.
But only about 30 of them, or 20-something of them, are actual policy. The rest are all comments
Yeah.
and commentary on the comments, which I didn't realize until I started. I'm like, oh, okay. But yeah, that was definitely, a slap in the face. Like, wow, that's 2,000 pages. But
You good to move on to page 2?
Yeah, for the purpose of moving on, Skip, did you have
No,
anything?
that's
for
fine.
page
That's all I wanted to get out at this point.
two? Okay.
Thanks.
Page 3, it talks about.
Page 2, we're good?
Yes.
Okay. Page 3.
Page 3, the very first paragraph talks about disseminating this annually. Can we put or sooner when applicable? Or are you fine with it being annually?
I guess I think it needs to be annually.
The only reason why I say or sooner when applicable is
If there's a
career
vacancy.
changes, all of that stuff. So I don't want it to just be like a,
I don't have a problem with adding.
I have that problem with anything that says annually.
No, I appreciate that. What we do annually is, we I meet with everyone, they get a copy of the policy, and we talk through it so everyone understands it. And then we do it with our volunteers, we do it with everyone.
We do it with as we employ people throughout the year, we do it
Yeah.
as well. So
Yeah.
is that what you mean by or sooner?
Yeah.
So if we hire a new paraprofessional,
We
making
meet with
certain
them.
that we get this in front of them also?
No, that's not what I mean.
Okay.
Like, if there's
Say Esther
changes.
decides to leave
Oh.
us.
Oh, okay.
We're not gonna openly talk about. So we would have to go through and update all of whoever would take her place,
I
because
see
they
what
would
you're
take
saying.
all of that
Yeah,
stuff, so.
okay.
I don't see a problem adding it if changes are made.
So they, or sooner if,
When applicable,
okay.
just so it doesn't put it straight in a box that somebody looks at it and says, you only look at this annually.
Yep, yep,
No, we make changes
As
if
needed.
they're needed.
yep.
And the only other thing that I found is that throughout the rest of the policy, they talk about education program versus educational on the first page. So just consistency there. So there's 2 at the bottom, under the sexual harassment, the very last line, it says education program.
Yeah.
And then on number 1, the very last sentence in that first is education as well. I'm channeling my inner Michelle.
So, I guess I'm just trying to understand, so it says educational program.
Under the purpose of the
Yep.
policy, it says educational programs and activities, and then through the rest of the
Oh,
policy,
yes, you're right.
it's all education programs.
I saw education programs, but I'm on page 2, so, yes, I would agree.
So I don't know if that was intentional, or if that was just a,
I would not know that.
Yeah, I don't know either. So we're gonna change education to educational, or are we gonna?
that's my preference, just because that was in the purpose statement as well.
At the very beginning there,
Yeah.
number 1.
Yes, I did read all 21 pages again last night.
That's good. I did it this weekend again, and it was like
Well, I
daunting.
appreciate you all being a part of my life.
I feel like I know a lot more now than I did before, but I still feel like I have a lot to
Take my
learn.
Yeah.
policies seriously.
But, well,
Esther.
I mean, that's, we were elected, and one of the RSAs is making policy, so it's
Absolutely.
being involved. I don't know, Nin, if you have anything more on page 3.
I do not.
Okay, I do.
Okay.
Under the definition of sexual harassment, we put in parentheses, including, without limitation, gender, sexual orientation, and/or gender identity. I think that needs to come out, I think, because on the narrow definition of Title IX, and it is on the basis of sex, which is defined in page 2000 and something as binary. I think we have our JBAB policy that would cover this. This is for sexual harassment, not discrimination. So I don't think it's necessary, and they talk about, like I said, on page 2000, and I have it here, that there were a lot of comments and questions pertaining to that, but they stuck by their narrow definition of sex. So I just don't see the need to add that. I think it muddies the water, and it takes us off the course of where these federal regulations want us to go.
That would be an attorney decision, yeah, I don't know.
Well, those words are not in Title IX.
You're
So if
right.
we're going strictly by Title IX, that is added in addition to what the feds are asking. So, and again, if you read page 2, the purpose of this policy is to address sexual harassment as defined in Title IX. I think it's abundantly clear that those words should not be there. I think we've deviated off the path. And again, I think we have a policy that covers all of this. We have a harassment policy, or a discrimination policy. This is specific to sexual harassment, so therefore I think we're veering off of where our directive is. Gosh, I can't even remember what I've got going on here today. Okay. Printed out too many pages. But they specifically say that sex is binary. They're going off of a Title VII, the civil rights definition. And again, right, we know that laws change, but as of right now, well, I might have to find it again, but it is in there.
No, you're right.
Do you want us to check with that, or do you want to just strike it?
I would move to strike it because I think it's very clear that this very narrow definition of sex is all that they are regulating us to cover. So I don't know how Nin feels about that, but, and like I said, if I can find the specific, it was page 2000 and something. No, it wasn't, it was page 550 something. I have more. I'm telling you, I spent hours reading and reading, but I may not, yes, no, that's COVID. What's this? Right here. Page 553, Title 9, 20, USC Code 16881, parentheses A, expressly prohibits discrimination on the basis of sex, which is why the department incorporates the phrase "on the basis of sex" in the definition of sexual harassment. The word sex is undefined in the statute. They wanted people were wanting them to define it, but they wouldn't. And then, so then it gives more examples of sexual, or the three prongs, the quid pro quo. And then it says, thus, any individual, irrespective of sexual orientation or gender identity, may be victimized by the type of conduct defined as sexual harassment to which a recipient must respond. So they're saying that those people are covered under this for sexual harassment.
So everybody's covered.
Everybody's covered still under
not-
anybody can be sexually harassed, irrespective of who you are.
Right.
But this is all it's talking about here. So I think when they put those in parentheses, these extra, definitions, I think it misses the mark.
I'm fine with striking it because it is truly, it's conduct on the basis of sex that we shouldn't have to put a definition in
Define
that of who that covers.
Other on page 3?
That's it on page 3.
Page 4.
You need me to point out all the education to educational.
I think we'll get the educational program, right?
Well, the question I have is, it'd be better to just move the first part to education program and leave all the education in, or make it educational, you know what I'm saying? So change the education.
Under Roman numeral 1?
Yeah.
Esther, is that what you're saying?
I personally don't care which way it goes as long as it's
I can sense
consistent.
that, so I'm wondering where it's education through the whole thing, except for that first.
Changing the one word versus
one
the rest of them,
word.
I would think that would meet the intent as
Yeah.
well. Yeah.
I knew that might be, that way we won't miss any or anything like that.
I don't think that first one would make sense though.
No,
No.
you're right.
So I would go
Just the
change
wording of it, is
other
that why they have the interchangeable, I wonder, because it makes
ones. Yeah,
the wording of educational programs in that section makes more sense than education program?
Well, I think in that case, though, it needs to be changed to educational programs.
At the
instead
beginning.
of- Well, no, not at the
Oh.
beginning, because that's what it says at the beginning.
Yep.
And then the other one, it takes off the S off of programs. So, but I mean, if we're all encompassing, it should technically be educational programs.
We're fine.
That's all right, we'll fix that.
You caught me on a really good day reading through this. Did you catch those? Don't always catch them.
Has to do with the kids, doesn't it?
I locked myself downstairs.
So, I've done that before.
You may have kicked them out. The only thing that I questioned on page 4 is the outside of the United States. Where does the school's trips to Spain and France, and where does that play in here? Because technically, that's
It
an
can happen there
educational
also. Yes, it
program,
is.
That's a very good point.
and
Yep.
they're on
Great
our
point.
time.
Great point.
They are.
So,
I
though, would
don't
this
think
not
that.
cover that, though?
It's not in the United States.
That's what I'm saying, so Title IX, though, does it?
Title IX would not necessarily.
It doesn't cover
it.
that, so it would fall under something else, I think. I'm just, was there a scope in Title IX that said specifically to the United States?
No.
So we could apply it to,
Although laws are generally nation specific.
No, it's a federal law, so it is to the United States. However, does a school trip, the question is about the school trip.
right, if it's a
Right.
sanctioned
School
school
trip,
activity,
maybe.
does it then,
I would think our policies definitely still apply.
So
Yeah.
I think if our
Sanctioned school
policies
trip,
apply,
there's no
then we
doubt.
should probably, you're right, we should include it in here. And that way we
Yeah.
know it's in there.
okay, so if the conduct occurred, how am I gonna read this? So conduct that satisfied this definition is not sexual harassment for the purposes of the policy if it occurred outside the United States, could we put in parentheses, unless on a school sanctioned
School-sponsored
trip? Yeah. I just have, I think, some clarification on the behaviors that constitute sexual harassment, and it's the last one there. And maybe I just wasn't reading it right the first time, because I am definitely opposed to any type of bullying, irrespective of what it is. So I'm just trying to, teasing or name calling related to sexual characteristics. Now that seems like one. Then if it's like, again, I'm just as my dissecting this, or now is it's trying to say that teasing or name calling with the belief or the perception that an individual is non-conforming to expected gender roles or conduct, because to me it looks like it's almost like, okay, teasing or name calling related to sexual conduct characteristics is not okay, or the belief or perception. So it almost looks like we're telling people what they can believe or perceive,
Right.
but I think it's trying to say teasing or name calling based on that, and I would agree that teasing or name calling based on that is absolutely unacceptable. I just think that it just seems a little, I almost think maybe we should split those out, make them, you know, again, I'm not sure if what I'm saying is making sense to you guys, but it almost looks like, I read it the first time really fast, and it was like, well, wait a minute, we can't tell people what to believe or perceive.
And you already eliminated gender identity just a few minutes ago. And here you're bringing it back.
Yeah, I mean, I'm just trying to see how it fits in to, well, I mean, because again, anything could be sexual harassment. I mean, we defined a bunch of things here, and then it just, I don't know, it just seemed like it was a run-on sentence, and then it was saying two different things. And then I guess this is just an open question too. So there is a teacher who was fired in Virginia for refusing to use the preferred pronouns. I'm just trying to, again, open question. How does, wouldn't want that to happen here. I mean, I think we have these supportive measures. I would think if we came into a situation like that we would try to like accommodate that versus forcing against someone's First Amendment right to, you know, engage in whatever the situation is. So there is this teacher that's fired, they've sued. Again, it's a mess, don't know the outcome yet.
I think that would fall under the transgender policy.
Well, that's what I'm saying. So I'm thinking, again, this is kind of getting outside the scope.
But the way that I'm reading it is I'm thinking that goes beyond. saying he or she, it's beyond that.
It's
and more of a
teasing or
sexual
bullying, and I
connotation.
agree, that's heinous. Like, I definitely don't stand for that at all. But what if it was just the persistent refusal to acknowledge that, okay, this person is now transitioned, but yet my beliefs or perception is biology is what it is. I will not, so it may not be like technically, teasing or name, but if it could be perceived as bullying if you're, and that's what's happening in Virginia with this particular teacher. They're saying, hey, you're bullying or whatever, when the teacher was, and I'm not going to get into the specifics, you can look it up, but I'm just trying to make sure that we're not going outside the scope of what Title IX is asking of us, and that, if that specific question, right? So we have a teacher or even a student who refuses.
Is it that, or is it, and this might just be my perception, is it the perception that a boy has longer hair, so he's being teased because of his longer hair, because somebody believes that is associated with a female? Or is it that a girl is playing with trucks and playing sports, and rather than what we may have called somebody as a tomboy in the back when I was younger, they now are teasing that young lady because she's not in a dress and
Right. Now that you're saying that makes sense. I mean, I
that's
can
how
see.
I kind of looked at it.
And I think maybe because just the page before it had thrown in the gender identity, that my mind was thinking, okay, but because non-conforming, but
Here's a way out.
I don't disagree with that, Kirk.
Yeah.
Change it to related to sexual characteristics or behavior and dump the rest. That, by changing that, you've now covered everything that has just been discussed.
Could you say that one more time, Skip?
Related to sexual characteristics or behavior. Which covers exactly what you just brought up.
See, and Kirk, I definitely agree with you on.
Because like in our kindergarten class, like there's a kitchen setup, right?
Right.
And
Yep.
so little boys will go in and play in the kitchen setup. And so I think it's kind of trying to protect them from being told by their peers
and-
that they are playing with something that is supposed to be associated with another gender,
Right.
like females.
No, and I totally agree, and I think that's valid. I don't know if it leaves it too broad. I mean, because I think you could then, you get a lawyer, and I think they, could turn that into, the non-conforming to, gender. I don't know, I think it's just as, I don't know. Again, I think Title IX is so specific, and now we're getting, again, none of these definitions are in Title IX. Nothing is in here at all. The only thing that's in here are the 3 prongs. So we're getting further away from what they're specific, and we can obviously add whatever we want. I just feel like we have other policies, but I do see where you're coming from as far as like, okay, a boy with a long hair, a girl that, plays, wants to play football.
Right.
That would be sexual harassment based on the non-conforming to expected gender roles. So I can see it going both ways. I just want to be careful that we don't have something that could be interpreted differently and then used outside of what we're talking about now.
Sure. Yep.
So I don't know, Nan, how you feel on that.
Would it be better if we took out just the or the belief or perception and just said teasing or name calling related to sexual characteristics that an individual is not
I think so,
conforming?
actually. Now that you say that, if we take those out, because,
In all retrospect, it is somebody's belief, I believe that girls should play with dolls, or I
Right.
believe that,
Boys should have short hair, or...
right,
it's the own person's belief, and I think that it makes it a little muddy that it's,
it just made it look like we were trying to like coerce people into certain beliefs or perceptions, and it's like, you're entitled to believe whatever you want internally, right?
Sure.
Once you start,
Absolutely.
expelling that externally, then yeah, we're getting into some, again, I disavow bullying in any form. If I find out that it's one of my kids, they're going to be beat. Like, it's as simple as that. We treat others as we want to be treated. But I think if we take out the words belief or perception and just leave it teasing or name calling related to sexual characteristics, that an individual is not conforming to expected gender roles or conduct, I think for me it at least cleans it up and clarifies it as, okay, it's specifically teasing or name calling related to this, not you get this belief and perception in here. I think that just, I agree. I think if we take those words out, I'm comfortable.
Sometimes these policies remind me of when I wrote English papers for college.
Oh, yeah.
The more words, the
Plug
better.
it.
Yeah, yeah.
Lawyers can do that.
Well, I think this section here, you're right, Kyle, this is really not part of the law, but this section here allows the average person to understand what the 3 prongs really are.
Mhm.
So it gives a reality base to it, so I think it's important. But
I had
but
examples
there's,
of the behavior.
yeah, but there's nothing really that says what it has to be here.
Right, okay. Yeah, and I don't have a problem with having the other ones there. I think, again, more definition is always better. But I was just, like I said, I think within the suggestion of just taking out those few words, I think for me, it clarifies it. It makes it obvious, okay, we are teasing or name calling. That is unacceptable. Yep.
Great.
I ask a quick question. Letter V, harassing or sexually suggestive of offensive messages that are written or electronic. The previous discussion was about on school grounds or school time. Is there a limitation to this? Does the school have the power to do anything that is not on school grounds and not during school itself?
Yeah.
Or any of
Well,
the
That's
activities?
discussed in another
In
policy.
JIC,
Okay.
Yeah.
in JIC that was just passed, and I believe it says, and I think I had a few questions and issues with this, but, and it had to do with if it, gosh, I'm gonna mess up on the words, but if it interfered with school, so if
Right.
it somehow
Right, yes.
carried over
Exactly.
into school.
Yep.
So if it's brought in, or like someone downloads something and brings it in,
And if it's on school, absolutely, I don't have a problem with, but an activity that
Here it
is
is
like
right
this
here.
outside of school boundaries or time, how far does this reach of the school go, is really what the question is on that. Because it's rather open-ended, you could say 24/7.
Well, I can read the JIC.
I think on the bottom of this, page 4, conduct that satisfies this definition is not sexual harassment for the purposes of this policy if the conduct occurred, number 1, outside of the United States, and we put in parentheses, unless on school-sanctioned trip. Number 2, under circumstances in which the school system did not have substantial control over both the harasser and respondent in the context in which the harassment occurred. Does that
I think
I think that satisfies what Skip is talking about.
I think it is too, because again, if you keep reading these 2,000, their scope is narrow. So I think
Yeah.
you're right. I think it's saying under, the school did not have substantial control, which would be a kid at home. We don't have substantial control over that child,
They're
therefore,
using an electronic device.
this wouldn't
at home
apply.
doing something.
Yeah. Again, unless they're, like you're saying, they're taking that and maybe a kid's at home and he messages a kid that's at school and then that gets passed around. I could see that as being applicable because even though the kid was at home, it came into the school. So I think you're right. It does state that when we don't have substantial control, that this policy would not apply. That would be my understanding here. Does that answer your question?
Yes.
Page 5?
Page 5.
I had, under C, it says shall respond promptly. We've had this discussion before of what is the definition of promptly? Is it business days, is it days? I think that we really need to define that.
well, the one thing it is, the days are defined in here.
Right, later
Later
on in the
on.
policy, yeah.
Yeah. So maybe we can
see section X of this policy.
Yeah, or we can just say the Title IX coordinator shall respond in accordance with the policy to all general.
Yeah.
Yeah, the word promptly drives me crazy.
Mhm.
Because I live in regulation world where everything has a time frame. And then the only other thing that I saw as I was reading down through those responsible fors is it discusses parent and guardian if it's a student. It does not discuss employee to employee anywhere in here. So does that revert to Kirk to discuss, or like, I'm not sure how that piece works. Or does that go to the board?
What part are you in?
Yeah.
When you go through the 1 through 8.
Oh, okay, we went to page 6.
Whoa.
Well, it just
It
spills
starts
onto.
on page 5.
Starts, yeah.
I am very,
Sorry.
I need help. Just ask my wife. Okay, you tell me page 5.
So when you go through all of what the coordinator is responsible
Right.
for in this piece, it discusses talking to the parent or the guardian if it's a student. It does not anywhere in here discuss if it's an employee to employee situation. What is the responsibility there as far as conversations, meeting with the complainant, that kind of thing? Because even in the first one, meeting with the complainant and informing parent or guardian. So are we to assume that meeting with the complainant covers employee to employee?
I think so.
Yeah, because it says complainant, so meaning the. Yeah, I don't, I mean, I think they're just adding the parent guardian if it's a, we need to. I think if it's not, if it's a teacher to teacher, I don't think that detracts from this. I think meeting with a complainant, right, and then the respondent will get addressed further down. I don't know if that,
What do you think?
if you're clarified or
Well,
not.
we can say meeting with, that's the way I take it, but we can say meeting with the complainant and informing the parent guardian, if dealing with a student, or, or you can clarify what a complaint is. I mean, it's defined.
And if you feel that it meets the needs, employee to employee, or if we need to have a separate one that talks about also meeting with the superintendent in that piece of it, to
Well,
it
the thing
becomes more
with
of
the
an HR
superintendent, you
thing.
have to wait until the investigation is completed, so he can be the second level. So,
Just even if it's employee to employee, Esther would be investigating that as well.
and that, because he has, you need to have enough, and it's very clear now, it was real fuzzy before.
Yeah,
But you need to have someone else besides the person doing the investigation that makes the decision of if
Right.
the person's found guilty. So
Right.
you need to have that next layer. So like, it was really clear in our workshop that I can't even talk to him about it until I'm completed, and then I give my findings, and then he can make that decision.
On page 3, complainant is defined as an individual who is alleged to be the victim of conduct that could constitute sexual harassment, whether or not the person files a report or informal complaint.
okay.
So I think that covers employee also.
Yeah, I would,
It was page 5, so I was getting a little into the weeds.
Yeah. This gets into the weeds.
But
There's no
we're gonna ask the
doubt.
It's better to ask, it's better to ask, believe me.
That's right, absolutely.
Other than that, I didn't have anything.
yeah, I was good with page 5.
6.
So I guess in cases where the Title IX coordinator is unavailable, the superintendent shall assure that another person, so are we going to have that other person already selected? Is it going to be another administrator? Could this be a board member? I'm just trying to understand you know,
Definitely can't be a board
when
member.
you're not
It
available.
wouldn't be as,
It would have to be another administrator because you still need that layer
Mhm.
that's really clear to make a decision once the finding is. So you still need those couple.
So we would already have that person defined, I guess is what
Well,
I'm,
our layers are right now is we have people in the school that can do the investigation.
Mhm.
And I would be the next layer.
Yep.
For majority of students and once in a great while an employee, but if it's employee against employee, it's been kind of our tradition that I would do it right off.
well, let's
the
say
bat.
you're on vacation or you left us.
Right.
Who would a student or a teacher know to go to
Well,
as that person?
In each building, there are 2 Title IX coordinators.
There's
and
so,
we've identified those and people.
They're
people
in our
know who that-
handbooks, they're everywhere.
so that's what so it's in our handbook already?
Yeah.
Okay, I just wanted to
Yeah.
understand, if something happens and you're not here, right, I can't go to you because you're that next tier. So
Right.
who do I go to? Who
Right,
does that person
it's all
go to?
defined very clearly. We have a male and female in each building.
Okay,
That is defined, that they're the Title IX coordinators.
Yeah.
A lot of the stuff doesn't even get to me.
right,
They make a decision and then we decide what we can do
Okay.
to support that person. The ones that only get to me are usually employee.
okay. Yeah, like I said, I'm just trying to,
Yeah, no, I appreciate that.
who would, you know, I tell somebody to go
It's a
to.
great question, but we have it defined in every building.
Okay. And then the training, so what is the training? Do we have that already? I know you've been through it, but and I'm assuming because this is an approved policy, nobody else has.
No, what quite often happens is we bring people in, or like I've been through it, so once you approve it, I will meet with each one of the buildings.
Okay, and then you would do the
And I would
training.
give them the information and then the stuff that I received from my training, because my training was basically a training to support other people.
Yep,
So then I would give them the same information. So once goes through, that's kind of why I was trying to rush a little bit so that I could have these 3 days
mhm.
to kind of train the people. But we'll,
Sorry.
no.
Well, it's, hey, like I was
No,
just,
I totally understand.
pandemic happens and we're trying to pass major policy.
Yeah, no, I appreciate that. So now, once this is through, then I will train, and then I will bring people in, or we can attend Zoom
Yep.
meetings.
So is the training from the feds? Is it specific training?
So last year, we brought in a lawyer, right? to
We
do
brought in
training.
Woodson and Drummond to train.
Okay, so they're allowing that. I didn't know if there was, because I didn't see it in here. If they, okay, this is the training that we want you guys to
Federal
teach.
government does not care what we do. They just say training, because they don't want to pay for it.
Makes sense.
So-
We don't want to pay for it.
Right. So we bring people in, so we do a nice job with training across the board, but now we'll have to train on this new policy.
Right.
So every, 3 or 4 years, Esther, has been kind of our.
Yeah, every 3 years, or for 3 years, I do the training, and then usually over the years, we've done little segments of training from little things we might see out there that we can connect into for the
Mhm.
state. And then on the 4th year, we bring lawyers in.
Okay. And I don't know if I see it here, and again, but I remember reading somewhere, it said something you had to have that training available or materials available online.
Yep.
So that's what I guess where I'm going is, okay, so what are we going to put online, or do we have already that in the works?
That has not, because that is just part of this policy.
Yep.
So when you pass this policy, I will put what I received
Okay,
already up online
Yep.
that I did in June,
okay, all right, that's,
based on
That
this
answers my
policy.
question,
So once we get this through, we'll put that up. So on the website, like, we do it for Title I now, where we have like a box of all the state report card and stuff like
Okay.
that. We would do that now. That's a new part
Yep.
of this, so we'll do that now. So
Okay.
people can click in.
yep.
Other things on page 6?
The other thing is that I'm working on is, part of this new policy is we have to have a plan. So this will be up online too.
Oh, okay, perfect. That's
So-
what kind of what I was looking for, is okay, what
Yeah.
information is going to be
So this
available online
plan,
for
I've been
parents?
putting in, and I've been looking at, I took some stuff that I had already learned, and then we'll create the plan, so I'm just
Okay.
waiting for this so I can put that in, and then this will be up too.
Very good. I don't think I have anything else on 6.
Mine was 6 into 7.
Okay. Bottom of 6?
Thank you.
The confidentiality piece
Yep.
doesn't talk about non-public board at all. Does that need to be spelled out in here that it may get discussed in non-public?
Well, well, it does say as much as possible. Right, so the district will respect the confidentiality of the complainant and the respondent as much as possible.
Right, and when we get into non-public, we don't discuss names or anything, but we do discuss scenarios.
But I think this is allowing for, I think this is, I mean, it doesn't say.
But
the
it
confi-
gives examples of required disclosure in here.
Uh-huh.
It does not discuss board meetings.
Now, again, I don't, this is just example, so you're right, so you're saying add an example, yeah, I would agree.
I think
To
that's
add
an
number
important
6.
one to add,
Yep.
because we do discuss
Because,
those
yeah,
in
people should
non-public.
have the expectation that it, yeah, it could be talked about in a non-public. I agree.
So number 6 would be a non-public board meeting?
Yeah.
Page 7?
Could I ask a question? As far as page 7 is concerned in the middle, about the confidentiality, one of the foundational policies of our jurisprudence is habeas corpus, the ability of the accused to confront the accuser. Is that completely eliminated in this policy? And could that get the district in trouble?
It is completely eliminated, I should be honest with you, in the federal law.
I'm sorry, say that again?
It's eliminated in the federal law.
Well, I know for K through 12, it's different than colleges, because in the colleges in this, it says that they're allowed to have, I think, an advisor on their behalf,
Okay.
ask questions of the
You're allowed to have an attorney.
yeah, and I think even,
That's in here too.
it is, but I think when you get to K through 12, that part was not required.
Okay.
So, but again, we're only on page 7. I thought there was somewhere else that did talk about, if you are the accused, that you do have, we have this formal process for you to be able to, I don't know if we'll get there.
It is.
But as far as somebody addressing their, what word am I looking for? Speaking directly to the person accused, this is the fact-finding piece. Is how I'm taking this. So that wouldn't come into play.
Yeah, and I think if we get further down, we'll see that there is a mechanism to be able to, and I think that was kind of one of the main driving forces behind the changes, was to give more due process to the accused. And I think that was, again, some of these thousands of pages that I read, that was a big part of what they were doing. So I think we'll get to that further down in here.
That was exactly why they did it.
Right.
Okay.
The only thing I have is under H, and it's gonna assume publicly available on the district website.
Yep.
The good thing is that doesn't have to be done until October 15th.
Yeah, there was another date in it. Oh my goodness.
Anything
Not to
else?
put any pressure on you.
Yeah.
No. I'm in a good spot once you guys decide this is it.
Page 8?
So now we just get into the procedural stuff, so.
Under records and record keeping, I know that we had changed emails, so does that mean all of the emails need to be printed for the 7-year retention?
If there's emails involved in this case, yeah.
Well, even emails going back to the complainant, because it says you can give them their documentation via email or electronic form, I'm assuming that we have to print all of those. Does that need to
So that
specify?
we need to be looking at our
here?
retention policy probably
Mhm.
for
Good point.
emails, right? Oh, yeah.
It continues to grow.
You're welcome. That's the first thing I thought of.
Great
We
point,
just changed that
great
to
point.
2 years, didn't we?
You did.
I can be honest.
Gosh.
Most situations though are verbal.
Yeah.
They're not email.
Right,
Very
right.
few have been
Yeah,
email related.
yeah.
So is there anything then requiring you to make notes of that?
Oh, yeah.
Yes,
yeah,
okay.
Yeah.
I have to do well, under the old policy and the new policy, I have to
Yeah.
do a formal report to whoever
Okay,
is going to make the decision of what happened.
okay.
If there's a finding. There's not a finding.
If there's not, correct, yep.
I still have to do a
Really?
report if there's not a finding, but I have to hold that report according to this policy for the period of years. However, I
And
do
we
not.
typically don't email those types of reports, right?
Never.
We don't
No.
even email like IT
Never.
stuff or
Never.
because of the security piece.
Mhm.
Other things on page 8,
That's all I had.
page 9.
The only thing I had is under number 2, the word promptly again. It's like one of my pet peeve words
Yeah.
along with the word basically. Hate that word.
Everything needs to be strictly defined.
Promptly according to the policy, or?
In accordance with the policy. Or respond in accordance with the policy when because it's in there.
Right, it is.
Yeah, they gave some latitude you're on, as far as 10 days, 90 days, 80 days. That one threw me a little bit.
Yeah.
Yeah, that was.
They really upped the days. It used to be a lot less.
Oh, okay.
Yeah.
So they really upped it, and I think, to be honest with you, I was a little caught off guard at first, but you rush to meet the 30 days, by
Right.
the time you.
Right.
So
Yeah.
now you can really contemplate and really get both people, you're rushing people through and saying, okay, I
Yeah,
have
it's not
30
an
days.
effective investigation if you
Right.
rush it.
Well,
For
yeah.
something as serious as this,
Right.
we don't want to take our, take it lightly, right, shortcuts. I don't think I had anything else on 9. That's good on 9.
Yep. The only section that I had is under emergency removal of administrative leave. It's I think it's the last sentence says the district shall provide the respondent with notice and an opportunity to challenge. Is that only for students? Because that whole paragraph only talks about really students, but talks about emergency removal and administrative leave too. So
Well,
it's
it
a
did
little
define respondent in the
confused
beginning
with-
though as
Yeah, I think
anybody.
it's for everyone.
I think so too. I think if you went back to the definitions, then you would
Yeah.
be able to apply that here.
But obviously I wrote that because I had the last question.
Yes.
So,
Then the second paragraph under that does talk about the respondent as an employee, right? And the superintendent may place the employee on disciplinary. administrative
Right, but it
leave.
was talking about specifically about notice.
Okay, yep,
That's why I had it underlined.
Right.
And the opportunity to challenge, the next paragraph doesn't talk about opportunity to challenge if you're an employee, which I thought was kind of odd.
Well, it talks about the grievance right before, I think it's page 9, that you can't make any final decision. But I think what it's trying to say here is, if the superintendent says you are on paid leave, you don't have an opportunity to challenge that paid leave.
right.
You do have an opportunity to challenge the grievance, which it says, no final decision can be done until the grievance is completed.
Okay.
And I believe we do have the right to put somebody out on paid
Absolutely.
administrative leave.
Yes.
Yeah.
Yeah, I did read that.
Yeah. Other things on page 10?
Nope.
11?
Oh, here's the grievance here.
Could be going back to definition here, but number 4, This is be signed by the complainant or otherwise indicated that the complainant is the person filing the complaint. Should that say or parent?
Basically,
Again, it could be definition thing.
yeah, basically, to sign by the complaint, under the law, you do not have to have a physical signed complaint. It can be a phone call, it can be, other ways. So you just have to define the person filing the complaint. So in other words, I say phone call by so-and-so.
Okay.
Filed that complaint. So you don't have to have someone physically fill out the form. Ideally, as you see it in here, they would like you to do it, but they acknowledge that that might not be possible.
I just didn't know if that needed to say parent of the person to file the complaint or person was fine.
I think person is fine because
Okay.
in some cases, I'll be honest with you, we have students who don't want their parents to know they're 18.
Well, right, and that's fine, but I'm thinking like, my own kid is 12 years old. They make the complaint to me, I call you and make the complaint. But technically that complaint is theirs. Or am I too far down the
I think you're
rabbit
going a little
hole?
bit in the weeds on that
Okay.
because I think, because
It's okay to tell me that.
It leaves you open here to say, or otherwise as a complaint, and as a person filing a complaint indicated. So you can say my child, that would be an indication to me, that's the person filing the complaint. Gives you a little leeway there, because I'll be honest with you, a lot of complaints come on Friday afternoon, and I'm talking to people on Saturday.
Yeah.
Okay, I didn't have anything.
Oh,
Page 12.
I didn't have anything on page 12.
I didn't really either. I mean, again, just getting into the steps here of, yeah, I don't have any notes on this page.
Page 13.
Sounds good, Ethan.
So this one made me stop and really think. Number 7 talks about if it's the superintendent
Yep.
that informs the school board chair. What if it's a school board member?
Yeah.
I know, I went way down the rabbit hole,
Right.
but.
Well, I mean,
And
it's
it's
a
It
plausible
doesn't
scenario,
Talk
right?
about that. I mean, would that go to the school board chair unless it's the school board chair? Like,
But it always has to go above. So like if there's an issue with the superintendent, then you have to go to the school board as
Right.
a Title IX coordinator. So if someone comes to me, you would have to go to above. So I guess the thing would be is if there's an issue with a school board member,
Does it go to the?
the state board,
Yeah.
I think it goes to the, I think the thing would be to the state board.
To the state board.
Yeah, I think I saw even something in here that
Yeah,
mentioned
well, it
that.
gives you, in your 2,000 pages, it gives you that.
Okay, I read it somewhere where it would say that, yeah, you would bring it to the,
But that one,
To the state.
that one section 7 actually made me think, oh, wait a minute. If it's a school board member, what is the process?
Mhm, mhm. Yeah, it would go to the next level.
And would we, is there anywhere, and I didn't see it, is there anywhere in here that gives the information to take that to the state?
No, there's not.
no, that's a great point. Maybe we should put that in there. How to, make that complaint,
Well,
or
it
who to
was
make it
in-
To
to.
make it too, right?
There was a section in the other one that talked about our old policy.
Our old.
That talks about bypass of a policy,
Mhm.
but this didn't say that anywhere in here,
Mm.
which I thought was really, really strange, and that goes to the NH Commission of Human Rights.
Well, I don't know if we even have the Human Rights Commissioner anymore.
Right, so,
Yeah.
I think that one's gone.
Yeah.
So I don't think that, that's probably why they didn't put it in. There's no one there.
We could certainly reach out to Will at the School Boards Association
Yeah.
and say,
Good
what
point.
about if it's a school board member or a school board chair? How do we differentiate between,
I think that, all-encompassing community, I think that it needs to be spelled out there.
Yep.
Because if it was a school board member and you still had a chair, the chair would be your
You
next
could-
person.
Right, right.
So it would really be if
If
it's a
it was-
school board chair,
Right.
that would be the issue.
I know, I open up cans of worms all the time.
It's your job.
That's good. No, it's good, I'd rather think about it, I mean,
Yeah.
that's
Before we get
probably
into
the
the
only issue I haven't
situation, not know
dealt with.
what to do.
Yeah, and then the feds are knocking on our door saying, why didn't you think of this? It's like, well, you didn't tell us to. I didn't have anything else on 13.
That's the only question I had.
Page 14.
The only thing I had circled was the 80 days, and honestly, I feel that's more of a determination of a talk-through point of, do all of these days, and that kind of encompasses a couple of pages, do all of these days, one, that they've defined out, equal up to the 80 days, and does that work?
Actually says there's 90 if you
Yeah,
add them all up, so maybe we should increase
Yeah,
that
that's
to
what I was
90.
like,
Because that's not spelled out in title,
It's
right?
not.
This can be up, I would say make it at least 90. Because if you got 10 days for each one of these or B through J, and then A, investigation 20 plus or minus days, that's the complex, so yeah, you could go well over 80. I mean, obviously, we don't want to drag something out either.
Right.
we can usually get them done,
But it says within, so it's not that we can't
right,
have it done
exactly.
sooner.
yeah, the footnote is that it can be modified, I just wanna make sure that that number of days matches the days that are
Which it
allowed.
doesn't.
It doesn't, because it's 90 days.
Right.
So 90 would maybe
90
be a better
probably
number to put in
better.
there, yeah.
That's the only thing I had for that.
Mhm.
More than halfway through, I'm full of coffee.
We have more coffee if you need. Page 15, we're moving along.
Getting there.
The only comment I had is, does this work for you, Esther? Number of days? I know that they
Yeah, I
provide
mean, I think
guidance.
it's always comes, what always comes in difficulty is when it doesn't say calendar days versus
Working days.
working days. Because I think, with vacations, if you gotta, that's what throws us off.
They can, for sure.
It can throw us off. So I don't know.
So
Now you're
private
thinking-
sector world, unless it says business days, it's assumed calendar days.
That's not necessarily the
I know.
educational world. I wish.
I mean, that would substantially increase this, though, if we
Yes, it
went
would.
to working days. I mean, you'd be talking,
Yeah.
almost, 30% more, potentially. So, I mean, I guess it's, in your experiences, going,
We can usually do it.
But
It's
it
just,
also gives that definition down here for delays and extension time. It
Yeah.
talks about holidays and stuff.
that's true.
oh.
Does give us the latitude, I think, to.
Yeah, I think it does. I think we're all right.
Yeah, and you may get a person who doesn't like that, but again, I think that's reasonable to expect that if we have, coming into the Christmas break, okay,
Right.
well,
And we're off
sure,
for 2
maybe
weeks.
maybe you can get in there for a day and do something, but the expectation to get, all, I think would be unreasonable.
Yeah.
So I think with, having the delays and extension in there gives us that out. No, I don't think I have anything on this page.
16.
You didn't have anything?
Yeah, and this is, Skip, this is just where it's going through, and it's saying, well, C is provide an equal opportunity for the parties to present witnesses and other inculpatory and exculpatory evidence. Forgive my English. So, yeah, I think it's defined that the
Okay.
accused has, the ability to have a fair trial, lack of a better word. I don't have anything else on here. You good too, Nan?
Yep.
Page 17.
So I had one question, and I don't know if this is something that we'll determine now or if we want to bring this to the full board. So, right, it gives you the choice of the standard right? So the preponderance of evidence versus clear and convincing. So is there a reason why we stuck with the original language and didn't change to clear and convincing?
Where are you?
I'm sorry, I should have, so number 8.
Okay.
And this was one of the big changes in Title IX. Now, it didn't mandate that we had to, so that's why I'm just trying to have the conversation. Is there
That's a good conversation to have.
is there a reason why?
I guess that would be a question for the school board association.
Okay.
This is what they've published.
Yep.
This is what they are.
Okay, well, I think that's something that we, to see some sort of, rationale, and then I think also too, maybe when we go to the first reading, that if anybody else has anything they want to chime in on, they can, because there's definitely a difference there. So that was my only question on, and I think it's, to mitigate the chances of false accusations is what was happening. Now, obviously, we don't want to make it so hard that if someone, is intimidated to speak out, because maybe their quite isn't that, something did happen, but they can't really prove it. I mean, we obviously want to protect all people, but I think, again, back to the original reason of why this is changing is because they were people that were accused wrongly, and then, sometimes it was years. I think it was the Duke lacrosse. It was a couple of years later, it was found out that those guys didn't do anything wrong.
Yeah.
And their whole lives were ruined. So I think, again, I'd like to hear what the...
How do we?
Yeah.
There was a
Yep,
case
yep.
in Alabama too, you'll see the same thing.
Yeah. So it didn't mandate that you had to choose, or the clear and convincing, but I just want to make sure that we're all understanding of, whatever one we choose and why.
Yeah.
And that was my only question on page 17.
Page 18?
I just had on dismissal of formal complaint, C did not occur against a person in the United States. We need to put in there school on the school
Unless
trip.
school sponsors. Yeah.
Good pickup.
I think it's good to put in our policy, but given that that's part of the federal, I could see an attorney just saying, it didn't happen in the United States,
Right.
Picking it right apart. Yeah, I don't disagree.
But I think it's good to have her, because I think everyone sees this and, gets them to think.
Right.
Right.
Yep.
Me as a parent, I'm giving you my child, and I
Right.
expect you to protect my child if
Right.
they're out of the country.
Yeah.
So if
Absolutely.
the sexual harassment thing comes up while they're out of the country, be it as another parent, another teacher, or another student, good luck to you.
Yeah.
Right.
Right.
And I think the biggest hitch would come is if it was a foreign person doing the
Absolutely.
sexual, if I think if it was
Right,
another
which
student or
then-
teacher, at least then, okay, we're part of the same group, but if you, then it's, I think, a whole nother level.
Yeah, that's a
Yeah,
whole nother
absolutely.
level, but if it's, in that, you need to understand what is our controlled environment in that point in time.
Yep, yep,
Why was my kid in a position in the first place?
right,
Right.
But I understand that things happen.
right.
So, I had A, B, and C on number 2 circled, and I think it's because of B, the respondent is no longer enrolled or employed by the district, that we could dismiss the formal complaint, but would we want to if something's happening and say teacher to teacher and they leave because they're uncomfortable? We wouldn't want to dismiss that, we would want to still do a full investigation, correct?
You can't do a full investigation because you can't get both parties to have a conversation with or to investigate. So it really leaves you hanging if someone leaves or if a student pulls out, because you can't get a true
Right.
investigation.
I think at
So
that
it never
point,
pulls out.
it's out of our jurisdiction, and then if there was something, then you'd
Right, and
report
that
it.
would fall under C because we couldn't gather the evidence sufficiently.
Right.
I
Right.
just found that them no longer being enrolled or employed made me feel like this is absolutely my own feelings, like, all right, we don't care anymore. They're no longer
Yeah,
here.
I think we
But
still
obviously
care.
we still have somebody here that
Right,
still
right.
needs to be investigated.
Right.
I just don't want it to be interpreted that way.
Well, it's the respondent, so maybe we can,
But that's the district doing the dismissal,
mhm.
Right,
not the claimant or the I just don't like the way that it's written.
I mean,
This is me being picky.
yeah, no, and I'm just wondering if we could just combine B and C somehow, you know, saying, okay, specific circumstances prevent the recipient from gathering evidence, such as the respondent no longer being employed by the district. I mean, that's nothing we can do, so if
And
that
not
makes the
responding.
verbiage better, you know,
Yeah.
it flows a little better, and as a parent, you're not saying, well, wait a minute, you know, it's okay, well, it's because we can't, you know, it gives that rationale. I don't know if that makes it more clear, or if it makes it more muddied, I don't know.
I understand the intent there. I get it. I just don't like it.
Right.
Yeah, no, I agree. I think it leaves a bad taste in your mouth, but I think according to the law, we're out of, it's nothing we can handle. Yeah.
Yeah.
It leaves a bad taste, but it doesn't leave the district vulnerable. I mean, that's. the
Right, and I get
Right,
that, and I'm
right.
looking
Yeah.
at it from that perspective too.
Yeah, I think that's the dilemma.
Yep.
Crop TV.